Okay, hello everyone. I suggest we wait maybe for 1 more minute so we have the participants joining. Welcome everyone. Okay, as as different participants join from different countries, I will share a brief introduction of our webinar today. So welcome to the third edition of the webinar series on intellectual property essential, which is part of the iPower SME initiative. It's a series that aims to bring together SMEs, especially those in the digital sector, but not only, and experts that work in the area of intellectual property, to share about their experience with IP and give advice to those SMEs that are looking to navigate the intellectual property landscape. Like I mentioned, this is our third edition, so if you would like to learn more about our first two webinars, one on strategies for business growth, and another one we organized on the theme of leveraging IP to fund your business, I will briefly share in the chat the links to it. For today's edition, we will discuss about the competitive advantage of intellectual property in the digital economy. And this webinar and the feedback we will receive from you today will represent the last step for the development of the practical guide for digital small and medium enterprises that we are working on and that we are about to finalize. And I have with me today the three experts working on the guide. So please allow me to introduce Astrid Videsi Avena, an Italian attorney focusing on strategic IP protection and on prosecution and opposition cases at both domestic and international levels. We also have with us Silvana Marcotuli. She's an international business lawyer specializing in intellectual property. She's mainly active in the fields of investments and international trade, technology transfer and internationalization of SMEs. We also have Davide Giribaldi. He works in the field of information technology since 1994, and since 2003, he's coordinating complex projects in the field of information security for multinational companies and for critical infrastructure of the Italian Central Public Administration. So to set the scene for today's discussion, I will invite Astrid to give an overview of the guide's content and what are the main topics that SMEs should consider when developing their digital products. So Astrid, I'll give you the floor now.
Thank you, Loredana, and welcome to everyone. Thank you to be here today. It is very important to us that you are indeed listening to this webinar, because our aim with this guide is to raise awareness about digital SMEs, about intellectual property rights. So we tried with this guide to give you some basic instruments, what we deem the most important instruments as a basis to deal with intellectual property rights, which of course, intellectual property law is a complex law, especially in the digital realm. But of course, there are some principles which might be easy also to grasp and to understand in order to leverage on intellectual property, also to enhance your businesses and to protect your intellectual property assets. I guess you already all know what is intellectual property in general. There have been many studies pointing out that SMEs often rarely have registered IP rights. And that's why also we will also show in our guide several assets that you might register, that you might protect with registered IP rights. Let's say that talking about the structure of the guide, we tried first of all to evidence what are the intellectual property assets of some digital products like websites and apps. So what can be protected? What is an IP asset? What kind of IP assets do we have there? And how can we protect them? Because of course, one product, one digital product can be protected by different IP rights. So this is the first important thing to know. And we try to give a picture of how to protect websites, apps, and then how to protect software. I mean, how, of course, many of us know that software is protected by copyright, but there might be also other tools to protect software. We briefly make the difference among registered IP rights, non-registered IP rights, such as trade secrets, and the ways in which all these tools can help you also simultaneously to build a successful IP strategy. There is a specific chapter also on artificial intelligence, which is a topic which is nowadays very relevant for each activity, I think, especially in the digital realm, which is carried out. Artificial intelligence is important not only for what is the use that digital SMEs can do, thanks to, I mean, how can they leverage, how can they use successfully artificial intelligence, but also what are the risks of artificial intelligence and what about the outputs of artificial intelligence, of generative artificial intelligence. And then, of course, a very important aspect, we will talk about in the guide, we will have a chapter about funding and IP rights. So how can SMEs leverage on IP assets to obtain funding, for example, further developing their inventions. And this can be done, of course, mainly by registered IP rights, but there are also funds which might leverage on other assets. And we will provide some examples, some practical examples, and also some practical examples on funds which are available. For example, the WIPO funds, the European Intellectual Property Office funding program. And then we will have a chapter which will lay down as IP strategy for each, let's say, moment of a project, for each phase of a project. So what are the steps? What are the things that I have to think about at the beginning before launching a project? What are the things which I have to think about from an IP perspective while, I mean, once my project has already launched, and what should I always bear in mind? And with Silvana and Davide, we have tried also to give some recommendations and takeaways for each of these different aspects. And I hope this will help you to have a first perspective and a clear idea on, okay, what are my IP assets and what could I do? What are the perspective of protection and enforcement and leveraging on this IP rights. I think, of course, this will not mean that we will not need to consult an IP lawyer afterwards, because we cannot, of course, go in depth with each kind of right. But I think this first step is very important to raise awareness on what can be done. And so I hope, I don't know if my colleagues want to add anything, but.
Okay, maybe not now, but for sure, as we start the discussion, we will learn more about the content of the guide. So like, you know, the format of this webinar is a questions and answers session. So we have received questions from the participants in advance, and we selected those questions, let's say, that are the most relevant for the topic of today. So I will start with the questions we received, and our experts represented here, they will answer and also try to include some of the parts that were included in the guide as well. So one of the maybe most received question is about what are the IP protection options for digital products or services, for example, for web applications, websites, software, and so on. So maybe I will ask Astrid as well to give us an overview of what are these options.
Yes, we have in our guide, we have made also table where we give an overview about the intellectual assets that can be protected in websites and in apps. So we have, for example, novel and non-obvious functionalities of apps, which can be protected by a patent, potentially, if, of course, the requirement of patentability are met, or by trade secrets. And we will explain during the guide that trade secrets are a kind of non-registered IP right that can be used whenever an invention, a technology, or a know-how is not patentable and is not protectable also by a utility model, but it has an economic value because it is an invention, and it has an economic value because it is secret, because only the creators know it. And so we, of course, give some recommendation for each kind of IP assets. So in case of trade secrets, our recommendation is to, of course, take steps of confidentiality, signing always non-disclosure agreements in order to protect the secrecy of such trade secrets, which are confidential information, because once the secrecy has been violated, the economic value is not more present, and you will not be able to enforce it. We have a trade secrets directive in Europe, so we just briefly talk about what are the requirements under the directive for know-how or an invention to be considered as a trade secret, and this is important to keep in mind also for you. And then, of course, for digital products, we have also trademarks, which can be associated with all digital products that you might launch on the market. And trademarks are very important because it's the first kind of IP right that you can register easily. It's a trademark, it means brand recognition in the market, and it's very important to have at least a trademark registration as an intellectual property right. Thanks to a trademark registration, you have a registered IP asset, first of all. You can prevent other parties for use a very similar brand as your product. Since, I mean, we have to imagine that for digital products, we have a lot of digital products that we can also find online. So it is important to differentiate your products or services through a trademark. And of course, having a registered trademark is also the first step for enforce your rights in case of someone copying your project or your invention or your app. Trademarks, of course, can be verbal or a logo. In case of apps, it's important also to register the logo by which your app might be known. Then, of course, digital products very often have a software. A software is, or it might be protected by copyright if it is original. And copyright protection arises automatically, so you don't need to register a software in order to have copyright protection. Even though in many jurisdictions, like for example in Italy, but also in other countries, you might register it at a copyright collecting society in order to have a proof of paternity. So we will explain all this stuff, and we will also explain that it is also the case of always indicating the copyright symbol on a website, for example, on the contents which are on a website and which are owned by you because you created it. You wrote maybe instruction, documentation, terms and reference of an app. This is all protected by copyright. And then you have also, of course, design rights, which might protect graphic and user interfaces, or even the look and feel of a website. This is also an important IP right, which is not used by many SMEs, but it's important because if someone copies your your project, your website, or your app, but without using your trademark, but using the look and feel, the same colors of a logo or something that gives the idea that it's you, but indeed it's another website, it's important to enforce design rights which protect graphic user interfaces. And then, of course, for a website, of course, you will have a domain name, a registered domain name. It's important to align trademark protection and domain name protection, because once you register a trademark, it is always recommendable also to register a domain name in as many domain name termination which you might be able to do it, like .com, .net, .org. And also, I mean, if it is possible, to register it in foreign countries where cyber squatting is a problem and where they could somehow then buy a domain name and sell services which are not really, which seem that come from your company, but indeed are not coming from your company. So all these aspects have to be considered when dealing with a digital product. This is, I mean, on the side of the intellectual property assets. Then, of course, we have also issues about enforceability and the fact that it's always advisable also to take adequate measures to protect your website also from cyber attacks, from different practices which are typical of digital world. I don't know if my colleagues want to add something. I mean, there are other authors of the guide. Without spoiling too much for guide.
No. No. I think that you give an extensive idea, I mean, and an important aspect. Maybe it's very important to understand, I think, that we are written the guide under European law, you know, because, and I would like to advise the companies that when they decide to go abroad, or in the USA or in other countries, they have a verify and knowledge about the legislation, because maybe in the USA, like in Italy, I'm Italian too, copyright can be registered. And in USA, it's an obligation, I mean, to have the protection from copyright in the Copyright Office in Washington. Some of the collecting society, I mean, the office that register copyright, have some bilateral agreement. Maybe a company in Italy can deposit the software or the content of the website as protecting the copyright, and ask directly a protection by the Washington office for the Copyright Office of USA. It's important to understand better what is the legislation in force in each country. But in USA, for instance, you can also register a website, the content of the website, under a collective work. I mean, the office put together all the app software.
Ivana?
Can you hear me?
Yes, now you were freezed. Sorry.
I'm sorry. Yes, the connection is not so stable. I'm sorry. Can you hear me now?
Yes.
No.
Hi.
I saying that it's very important because in the Copyright Office of Washington has elaborated some registration of website work, content, website, and software contained in the website under the same group of registration. So it's really important when you go abroad, understand what is the legislation that you want. As a practical point of view, from Europe, you can obtain a trademark valid in all the 27 countries, depositing the trademark at the OIPO. And we have also now in Europe the unitary patent, so you can deposit just one application and then ask for the protection all over the European Union countries. So this is just to give an idea that there is nothing in this stage and this occasion. We are not to go deeper, I think, to all the procedure that you have to do. But it's important to understand that.
Thank you, Silvana. And indeed, one of the other questions that we received is how to protect your IP in Europe, USA, and other countries, and the path to protect our IP worldwide. And I see also in the chat someone asks, how do we expand from Europe to worldwide the algorithm IP protection? So is there anything else that you might want to add on?
Yeah, you have to, I mean, for the procedural point of view, you can start with maybe the deposit of the national trademark or the national patent or on copyright, and then ask for the extension. The legislation allows 6 months for marks and 12 months for patent, but you go international. I mean, you can deposit directly to the World International Property Office, WIPO, based in Geneva, and under the PCT agreement, I mean, the international patent, for instance, and then or for the international trademark under the Madrid agreement. And you can ask for the extension in the countries that your company or your business is interested on. So it's longer procedure. It's a quite long procedure, but you can deposit an application in just one office, and then the office will contact all the. Of course, when you go in, while in Europe, in European Union, we have the same regulation now in 27 countries. When you go abroad through the WIPO, the first is the international phase. I mean, and then you have to go to the national phase for each country that you selected. So in order to comply with the requirements of each each country is required for patent or for trademark. For instance, in the United States, you have to sign a declaration of effective use. So it's very important, no? We say that to maybe have already used or you want to use in 1 year the mark in the USA. I don't know if
Okay,
there's other question.
Thank you so much, Silvana, for giving this overview, let's say, on different procedures in Europe and also abroad. And maybe in the chat, we have a question that kind of takes us to the next parts and an important part of the guide, which is on the impact of artificial intelligence. And to link it to another question that you received, which is, what do you think? Would you think the traditional approach to protecting and valuing companies' IP assets should change in the AI age? And if so, why? So, and I would like to invite Davide, who is our expert on artificial intelligence and cybersecurity to address this question?
Well, first of all, let me say thank you for this opportunity to share the floor with such important expert like Astrid and Silvana. I'm not a lawyer, so it's very interesting for me trying to think about IP protection, not only from a technical point of view. I think that to right answer to your question, we must first consider that AI has already changed our lives and will change them more and more in the next few years. So the same for sure just happened to IP asset protection. In this wide-changing situation, we can see both risks and opportunities. But because, first of all, I'm an optimist, I would like to start from the opportunities. Maybe that we should all agree that for small, medium-sized companies, patents or IP rights can increase their value, especially by protecting, for example, the interests of potential acquirers. And in my humble opinion, founders or senior executives should develop an IP protection strategy to enhance their company's appeal to larger companies. And I think also that the presence or absence of patents or IP right protection can greatly influence acquisition prices and the success of due diligence, for example, by larger companies. But from the other side, I think that, for example, litigation should be a critical aspect, and multinational companies can afford to litigate, whereas small companies should avoid them due to high costs and the risk of being shut out of the market, for example. For these and other important reasons, I think that effective IP protection, adopting an effective IP protection is a strategy, a vital strategy for small and medium companies. I found, for example, 3 or 4 focus points that I wish to share with you. The first one should be considering, for example, licenses agreement. When external data sets or algorithms are utilized, securing appropriate licensing agreements is paramount. These agreements must define clearly the scope of use, ensuring AI companies, for example, to possess the necessary right to integrate those elements in their technologies without violating IP rights. The second focus point should be community contribution. In instances where AI develop and enhance existing IP or generate new IP rights, companies should, for example, explore ways to give back to the community. This could be take from the forms of releasing dataset, publishing research finding, or something of the kind. And such contribution foster a culture of collaboration and innovation, while still protect proprietary advancement. The third focus point, I think, that should be protecting company innovation, because for IP company, proprietary IP companies, they need to strategically select the appropriate protection. Should be patents, copyrights, or trade secrets. The decision, this kind of decision, I think that often hinges in the IP natures of the company's strategic objectives, so weighting the benefits of public disclosure against the need for maintaining a competitive edge. And the first one, the last but not least, should be IP audits and compliance check. Conducting regular audits on methodologies or employed in AI development can identify preemptively potential IP infringement. So this is my opinion, and I hope to answer in the right way to your question. Thanks.
Thank you. Thank you very much, Davide. Indeed, artificial intelligence and IP is starting to become a focus point also for companies in general. So we will keep an eye on the discussion, and if among our participants there are other ideas or other perspectives, I invite them to share them with us. I would now suggest going to the next part of the discussion. After we learn more general information about the IPA landscape, impact of new technologies such as artificial intelligence, I would like to go to the business phases themselves. So I will take another question that is let's say related to what is a SME supposed to do before launching a product. So the question is, how do you get started with IP strategy? When should you start? Do you need an expert lawyer? So maybe I would like to invite Silvana to address this question and maybe the business part of it.
Yes, thank you. Yes, it's very interesting question, you know, because it's a very important that company have a strategy. The IP, but
No, I think we lost Silvana again. Then maybe another one of you can help me with this question. And Astrid, would you like to maybe add something else while we hopefully get Silvana back? I don't hear you. I think you're still on mute.
Yeah, sorry. I mean about the different phases of a project, right? So Silvana was talking about the need, I mean, the importance of a business plan, of course, and she would, maybe she's back. Silvana?
Yes.
Can you hear me now?
Yes.
I'm sorry, I don't know what happened with the connection.
Yeah.
Yes, I said the strategy and the business plan, as Astrid was mentioning, I heard, because it's very important before to start the project, and then we will see with Astrid after, I mean, how to control, I mean, and verify all the assets. The business plan must examine the feasibility of the business idea before to go to the market, before to start. I mean, and the IP lawyer or IP expert, it's very important in order to understand what kind of protection, because as we said, Astrid before, there is a portfolio, could be a portfolio of protection of the assets, and or maybe in some cases it's better to not register but to use the trade secret. So it's very important to understand the business plan, how the asset, how the IP is important for the business, and how for the product or the services, and understand through an evaluation and developing a robust boosting plan around intellectual property rights. It's a very crucial to ensuring the protection and commercialization of the product or the service. Why the business plan? Because the business plan can help in order to go step by step also, you know, and to understand how and in which market maybe protect the asset of the IP, and how revenue, the amount of revenue expected must be controlled. In the business plan also we consider the critical employees, the delivery technology, the strategic plan to commercialize, to put on the market the project, the products or the services. So it's very important also have a business plan, also to have access of financing, because for the investors, it's really important to see that the protection of the IP, I mean the asset, is and its value. There are some questions that you have in the guide. In the guide, we have put some example and question that the company has to put to themselves, ask themselves why they are reading, they are writing the business plan, considering the IP asset. I don't know if you want to go deeper on the content of the business plan, or just give an idea. It's sufficient.
Thank you, Silvan. I think we will have the chance to share more information in the guide, and we have also had another session dedicated to business growth. So what are those steps that you need to consider also when you're developing your business strategy in terms of IP? But maybe I would like to give back the floor to Astrid if she wants to add something.
Yeah. No, I just want to add that a very simple thing. I mean, the first step before launching a project is to understand what are your IP assets. The first thing, because as you see in the question, the most natural thing is to think, I have a software or I have an algorithm, but most of the times that's not the only thing that is owned by the startup or the smallholder company. So it is important to identify those assets and then to understand how to protect them, because an efficient IP strategy goes with a portfolio, as Silvana said, multiple IP rights, and that's a very important concept to bear in mind.
Thank you very much.
I see a question. Okay, should I?
It's the guide. When it's not available yet, we are working to finalize it, and it will be available, and we will share it with everyone in the next few weeks. And then we will do another webinar. We will do another webinar in September, and then we will have the chance to follow up on the content of the guide at the time. And I think Astrid was talking about the question in the chat, right?
Yes. No, I see that there is a question. Understand we must register in our country, and this being within the EU and will be valid in EWIPO, right? If not, in which cases should we contact EWIPO directly? I think it depends on what IP right we're talking. So for trademarks, yes, you can register your EU trademark directly within EWIPO. EWIPO has also a fund going on now for SMEs, whereby you can, obtain a voucher for covering almost 75% of the taxes. But this is valid for trademarks and designs. For patents, it's a little bit more complicated because you don't have a unit. You don't have just one title which is valid in whole Europe. It's a little bit more complicated. We will go more deep. We will explain this in the guide. But in any case, it depends from the IP right. For copyright is always national. Each member state has its own copyright law. But what Silvana was saying before is that you can register it at a collecting society in your country, and then there are some agreements among collecting societies so that it is recognized as a paternity proof. And in the US, it's very important to register it, because the US Copyright Office, if you have not registered your copyright, you cannot enforce it before the court. So it's very important in the US. Here, it's not mandatory, but of course, it's a very good proof of paternity.
As if I can add something about the copyright. Copyright is free from registration almost all around the world. Okay, for the countries that are party of the Berna Convention on copyright. But the problem is, as Astrid said, you have to prove before the court that you are the owner of the copyright. So in some countries like Italy, USA, India, there are offices that are competent for the registration of the copyright. So it's important to understand and to know, to have some information about the legislation in place, in force, in the country that you want to go. I mean, for in Europe, there's the directive with the copyright approach, and there are some collective society or in a notary. You can deposit. You have to prove. You have to demonstrate that you are the owner. So when if in your country there is no office competent for this, you can also deposit before a notary to have a proof that at certain date you develop a certain software or whatever.
Okay, thank you both. And maybe I would like to stay on the topic of EU IPO. And I have here, it's not a question, but it's someone mentioned that they would like to, they appreciate the EU IPO SME fund and the vouchers that they give. And they mentioned that they would like to understand more about them. So indeed, there's this SME fund from EUIPO. And I would like maybe Astrid, if you can tell us more about this fund and how can SMEs apply to get funding for their IP assets.
Yes, this is the Ideas Powered for Business SME Fund of EUIPO, and it supports SMEs to register their registrable IP rights, in particular trademarks, design, and patents. So to participate to the fund, the SME has to prove that it is an SME according to the EU applicable legislation. And basically, the company, I mean, the SME has to apply for the fund, and EUIPO within 15 days says if the request is accepted, and it gives a voucher to that SME that it can be spent for registering the IP right. What is important to say is that one SME can apply for one voucher, so you cannot register 5 trademarks or too many IP rights, of course, because it's a fund who has to help many SMEs around Europe. So once you have the voucher, then you have some time for applying to the right. This is very useful because at national level, very often there are also funds, but before you have to register the IP right, and then maybe they give you back what you expended, what the expenses were to protect the IP right. In these cases, they give you a voucher, so you don't have to anticipate the money. Basically, you just have to pay the 25% that remains to pay from taxes. And then, of course, if you appoint representative, which can be a lawyer, an IP counsel, to do the registration for you, and I advise always to do this because many times we are consulted by companies who they did it by themselves, and then something happened, they got oppositions, they got problems. So I advise you to ask for an expert advice before filing an IP right, because then it avoids you problems on a later stage. And so yes, it's a quite simple process. You just have to prove that you are an SME. So it's I have to say we never, I mean, as a law firm, we never had problems in such respect. The only problem is it's the funds, of course, is first the first who ask for the funds, are the first who are served. So the funds might be terminated at a certain point. Last year they terminated in October, so there might be some time, but I urge you to consider it as soon as possible.
Thank you so much, Astrid. And indeed, I added in the chat a link to a step-by-step guide on how to apply for the SME fund if anyone is interested. All right. I then suggest we go to...
there is another question in the chat but regarding copyright. Can we register a text made partially with ChatGPT or alike? Well, this is very interesting. I mean, the US Copyright Office was the one dealing with, I mean, it is like say the authority which until now has dealt the most with content created with ChatGPT or other artificial intelligence. The point is, normally copyright protects works of the human mind, so where there should be a human intervention. How much human intervention there has to be, this is the thing which is debated right now. The US Copyright Office, if you go to the website of the US, it's very interesting. They made some rules because they examined many cases where, for example, there was a work made with the help of artificial intelligence, but then there was, you know, a human intervention. They made it better. They changed it a little bit. And so, yes, it can be copyrighted. But in other instances where, for example, there was how do you say fumetto? You know, Tintin. How is it called? Oh my God, I don't know.
Cartoon animated.
Exactly, cartoons. There was
Cartoons.
Entirely made with artificial intelligence, and the author just he wrote the text. He wrote the text between the characters, and he submitted to the US Copyright Office, and then he made a whole marketing saying it was all made by artificial intelligence. And the Copyright Office said, so sorry, we cannot protect it because we can just protect the text and not the images, which are all done with artificial intelligence. So it's something to be careful with. But of course, if a text is made partially with ChatGPT, it's difficult to know nowadays what is made with ChatGPT and what not. So, yeah.
Some jurisdiction. Sorry.
Yeah. Go on.
If I may.
Yeah.
Some jurisdiction requires that the part of the works made by ChatGPT must be evident. I mean, you have to declare, you know, even if you reformulate the work, and it is the case here in Italy. This is not a copyright of software regarding software, but it's a copyright regarding artwork, scenography, that an architect will ideate to the basis of a ChatGPT and then reformulate with an intervention and publish this kind of photo or works or in her website. Because said that was through ChatGPT part of the work, RAI, I mean our television broadcaster, public broadcaster, used this in the very famous entertainment program that is a Festival of Sanremo, and the architect sued RAI and won, because the intervention, she declared what part of the art of the scenography was with the intervention on ChatGPT, and she can prove how she modified the work of ChatGPT. And our Supreme Court recognized the damages and the counterfeiting of the work. So it's of course it's an argument, very complicated, very underdeveloping, you know, the development from the court, from the offices.
Indeed. And it's an argument that is very popular, and there is a lot of interest on it. And also in the chat, we have another question. You can use a framework or Canvas to apply intellectual property to AI projects for EU and USA. For me, it's not very clear.
Yeah.
Please go ahead, Silvana.
No, I would like to have more. It's not very clear. I mean, the question. You can use a framework or Canvas to apply intellectual property.
Okay, so maybe if Alberto can give us more.
At least for me, it's not clear. I don't know if Astrid or Davide.
No, it's not very clear.
I'm not a lawyer, so.
No, I don't understand what he means by framework. Canvas.
Okay, maybe in the meantime, if hopefully maybe we can get some more information. But in the meantime, I would say we take one more question from the questions we received from participants prior to the event, and then we will continue with some final information about our next activities. So I would like to take the question on how SMEs can effectively commercialize their patents. So we go also in this topic of exploiting intellectual property and commercializing intellectual property. Silvana, would you like to go for this question? I'm not sure if she can hear me.
Anna?
Okay,
I think she's freezed again. Yeah.
Yes, I think we've lost her again. So
Yeah.
maybe.
Eccola.
Maybe Astrid can say something. I don't know if you want, but it's very interesting, you know, because this is an argument for you can exploit the.
I'm not sure. I think we lost you for a moment, and I'm not sure if I was going for the next question in our list on exploitation of patents. So I actually invited you, Silvana, if you would like to discuss this a little bit. So we go also in the part where SMEs can actually commercialize intellectual property. What are the options?
Yes, can you hear me now? Sorry,
Yes.
I'm very sorry for the bad connection. I don't know what happened because you know it's another storm here, but sun, maybe our technology partner. I don't know. Yes, there is a very interesting. I mean, to exploit patent and IP asset in general, and that depends if we are talking about licensing. I mean, with the IP rights can be assigned if you want to sell to another company, or better to license the IP for a collaboration with the other company, or with or just to give the use. I mean, to the end user or another company that can utilize in internal or own business. There is an argument interesting in this field that is a transfer of technology, and that can be utilized from maybe for research in university. I don't know if you want to to give much deeper and analyze, I mean, how to transfer, I mean, the IP, the patents, so that can be. I lost.
No, we can still hear you. My only concern regards time, because we only have 5 more minutes. So I would say we can always follow up if necessary, if the participants are interested in the topic. But otherwise, is there anything else you would like to add, Silvana?
Yes, I just to say that it is very connected to the business plan also. How do you want to utilize your IP, your IP asset? And what is your goal? To go to the market directly? If maybe if you are a software company, you can do this and try to enter the market. If you have a more complex business, you need partners, maybe. So the exploitation in the guide, there is some information about this. It's different if you want to go directly to the market or to provide the services with a partner, and you want to have finance for this. So we divided the argument in the guide, but we have to consider all together the strategy. First of all, the strategy, then how to protect. I mean, at least the most important asset that is a very fundamental for the business. Then, if you don't want to do this, at least as Astrid said, register a trademark, register your domain name, so you have something that can protect your activity before, and use confidential agreement. I mean, when you talk to the other party or the possible partners, must kept secret all the information, all this change about the innovation.
Okay, great. Thank you. So we have 2 more minutes until the closing of the webinar, and I would actually like to share with you what are the next activities that we will organize. And if this was interesting for you, feel free to join us for the other initiatives. So I will briefly mention that in September, we will organize another webinar where we will showcase a series of best practices from SMEs that have successfully leveraged their IP to grow their businesses. So feel free to join and interact with them. And also, if you wish to contribute yourself to the knowledge ecosystem that we're trying to build here, for SMEs regarding IP. We have an ongoing call for best practices to share insight strategies that have proven effective when it comes to intellectual property for SMEs in our community. And like I mentioned, in the next couple of weeks, in the next few weeks, we will launch the guide. So again, if you think this was interesting, we would appreciate to have your feedback on the webinar and on the guide once it's launched. And complementing the guide, we have developed a map of contacts with potential collaborators and IP support services at national level for SMEs to connect with potential partners, explore collaborative opportunities, and access support service at national level. So please have a look. And if you yourself offer support services or legal advice to SMEs, I would like to invite you to register your contact to this stakeholder map, which is very easily done at the link that I share here. And one last thing before we close the webinar, I would appreciate if you could give us your feedback on the discussion today. There will be a poll that will appear now on the screen where you can let us know if you enjoyed the webinar. So I'm going to leave it open for a minute. So please, it's just there are only 2 questions regarding your satisfaction with the webinar's coverage of IP topics relevant for digital SMEs. And the second question is it's about the location where you have your activity. So maybe we can close this question and we add the next one. Please let us know where you are looking at us from. After the webinar, the recording will be available and there will be a follow-up email for everyone with the recording, with the presentation that I shared throughout the webinar, and also information about our next activities. So you will receive all the details. And also, if you want to get involved, feel free to contact me at the email address on the next slide. We will share all the information. Okay, thank you, everyone. And indeed, I hope to see you in September for next activities.
Thank you all.
Thank you.
Thank you, everyone, and
Bye.
thank you, Loredana.
Bye.
for-
Bye. Thank you so much.
Bye-bye.
Thank you.
Bye-bye.
Bye.